Excited Utterance, the Evidence and Proof Podcast, Episode 164 Stephen Simon Value Judgments in Judicial Reasoning and the Instability of the Fact Law Distinction. Welcome to Excited Utterance. I'm your host, Alex Nunn, from the Texas A&M University School of Law. Excited Utterance is your podcast for cutting-edge scholarship and developments in the world of evidence and proof. We bring virtual workshops to you throughout the academic year. Joining me on Excited Utterance today is Dr. Stephen Simon, an associate professor of political science, as well as philosophy, politics, economics, and law, better known as PPELE, at the University of Richmond. As you'll hear, Stephen and I chat about one of his recent papers entitled Value Judgments in Judicial Reasoning and the Instability of the Fact-Law Distinction. Now, when I first read this paper from Stephen, I immediately knew that I wanted to have him on Excited Utterance because the law-fact distinction is such a fun, engaging, and interesting topic. At the most intuitive level, it seems so simple. The question of whether the defendant punched the victim, that's a question of fact. The question of how we should interpret the First Amendment, that's a question of law. But as you work in from those polar extremes, you find a murky middle ground, a murky liminal state between questions of law and questions of fact. Reasonability, for example, is a question of fact in the tort context, but a question of law in the contract context. The voluntariness of a search is deemed a question of fact, but the voluntariness of a confession is deemed a question of law. And naturally, this confusing middle ground between legal and factual issues has spawned a plethora of really fantastic scholarship. So in my podcast with Stephen today, we survey the literature, seeing what's been said before about the law-fact distinction, before we dive in and focus in particular on Stephen's most recent intervention. Steve, welcome to Excited Utterance.
Yeah, thanks so much for inviting me. Glad to be here.
So today we're talking about the law-fact distinction, which I have to say, it's something of a popular topic in legal scholarship, including my own work. I was drawn to it back in my early days of my career. But I want to begin with the basics just for our listeners before we get into anything too complex with the law-fact distinction, because it's a topic with a ton of depth. But first, just remind us, what is the law-fact distinction?
Yeah, the law-fact distinction is a classification of questions that come before courts. So courts classify questions in litigation into two major categories: questions of law and questions of fact. And it's a distinction that I assume is very familiar to many attorneys because it impacts so many different aspects of litigation. So, for example, at trial, the usual rule is that judges will decide questions of law while juries will decide questions of fact. And on appeal, appellate courts will give no deference to the trial court's legal findings, but they show great deference to the trial court's factual findings. And those are just a couple of the examples. So it has a big impact on litigation. And it's a distinction that really jibes with common sense. So the usual short, concise way we could describe the distinction is that legal questions concern rules that basically tell people what to do and not to do, like statutes and administrative regulations, while factual questions concern specific events and circumstances, questions like what happened where and to whom. And so just to give a quick example, the question of what's the speed limit on a particular stretch of highway, that would be a legal question. The question of how fast was a particular car traveling at a particular time would be a factual question.
Perfect. So I want to follow up on something. You mentioned that this accords with common sense, it's intuitive. The law fact distinction, it seems pretty basic. So why then has the law fact distinction gained so much traction in the literature? I mentioned the depth that there is to this issue. How is it complex?
Yeah, exactly. It does seem so basic and so intuitive. And I think that's a part of what makes it such a puzzling and interesting topic. So I think of it as a puzzle. On the one hand, as we were just talking about, it seems very intuitive. Who doesn't understand the difference between a speed limit and how fast a car is going? Also, it's been around for a very long time. It has roots going back to 16th century England. Courts have been applying this distinction for centuries. And so you would think that it's a pretty basic distinction, courts have been using it for a long time, maybe things would be pretty sorted out by now. But in fact, and this is the other part of the puzzle, courts have really struggled to apply this distinction in a consistent way. As courts themselves have recognized, the case law is a mess. Just to give one very quick example, the question of whether a defendant acted negligently, acted with reasonable care in a torts case is treated as a question of fact on the grounds that it involves judgments of reasonableness. Yet at the same time, questions of contract interpretation, which also seem often to involve questions about reasonableness, is treated as a legal question. Another thing that makes it puzzling is that the more you think about the distinction, the less clear it becomes exactly where the line is to be drawn. So there are easy cases, like I mentioned, the speed limit case. But take a case like whether a defendant was driving recklessly at a particular time. Is that question more like asking how fast the car was going, or is that more like asking what the speed limit was? And the more you think about it, the more it becomes hard to draw exactly where the line should be. And so this has raised a number of questions. One, I think, really interesting question that this raises is, what is the relationship between what courts are doing when they make these determinations of what's a legal question versus what's a factual question, and whether there's an actual real world distinction between legal and factual questions underlying that? Courts tend to talk as if there is a real world distinction independent of anything they're saying that they're trying to track. So it's as if there were no courts, there would already be a distinction between legal and factual questions, and they're just trying to track that real world distinction, which is worth noting because courts don't always do that, right? If you have the doctrine of forum nonconveniens, we don't tend to think of that as something that exists in the world independently of courts. It's a term of art that's defined by courts. But since courts treat this as if it's a real world distinction, it raises the interesting question of, is there a real world distinction between legal and factual questions?
Perfect. And in response to that complexity that you just talked about, courts are struggling with this border division between law and fact. You know that there really have been two approaches that have gained traction in the scholarly literature as potential explanatory accounts. So let's dive into those. What's the first approach that we see in the literature?
Yeah, so one major approach, which we could call the traditional approach, is one which accepts the traditional, the intuitive distinction between legal and factual questions at face value. So it says, is there a real world distinction? Yes. We have laws, or legal questions are questions about general rules. And then we have factual questions, which are questions about specific events and circumstances. And the traditional approach, since it views those as clearly delineated categories, it views litigation as occurring in stages. So first we can identify what the legal principles are, then we can determine what the relevant facts are, and then we can apply the law to the facts. And the key is that those elements of the analysis can be kept separate. They can be compartmentalized.
And let's go to the second account now. What's the second approach in the literature?
The second approach takes the opposing view that there is not a real world distinction between legal and factual questions. And one especially prominent version of this view, actually one of the most influential articles on this, was written by scholars who will be familiar to listeners, Ronald Allen and Michael Pardo. And they wrote an article called The Myth of the Law-Fact Distinction, which has been very influential. And there are a number of other scholars who take a similar view, but because they describe this view so clearly, it serves as a useful foil. So I'll sometimes focus on their view, even though there are many scholars who have articulated similar views. So in their view, the reason why there's no real world distinction between legal and factual questions is that all questions are factual. And the reason for this concerns the way that they define what a factual question is. So according to Allen and Pardo, a factual question is any question that is about a proposition that could be true or false, and which could be supported by evidence. And then they apply that definition of what counts as a factual question to what the traditional view calls legal and factual questions, and concludes that they both come out as factual questions under their definition. So this does not seem very surprising with respect to traditional factual questions, right? How fast a car was traveling on the highway. Clearly, that's something that could be true or false, and something that we could present evidence about to establish its truth or falsity. But in their view, what are traditionally called legal questions also count as factual questions, because a question like what's the speed limit is also something that could be true or false, and that one could present evidence to support. So since both kinds of traditional questions end up counting as factual questions, in their view, the distinction breaks down.
So let's put our normative hats on for a second, because you've done an excellent job of kind of unpacking these two different competing approaches, but I want to scrutinize them. I want to look at them both critically. So you find shortcomings in both of the models, actually. Let's take the traditional model first. What problems do you see in the traditional model?
Yeah, it seems to me that the traditional model does get something right, which is that there is a distinction between legal and factual questions, if I can put it this way, if we're thinking of things in themselves. In other words, if you take away our human involvement in making decisions about legal and factual questions, that there is a distinction between general rules, abstract norms on the one hand, which can apply to an indefinite number of things, versus questions about specific events and circumstances, things that happen at particular times and places. But we're not talking about things in themselves. We're talking about decision making in the context of litigation. And once human beings get involved in making decisions, the analysis of both kinds of questions becomes pervasively value laden in ways that make it impossible to keep the two kinds of analysis separate. So let me just give a couple of quick examples. When we think about legal questions, we're talking about norms which pursue valued ends and prescribe behavior, and we have to interpret them. We have to give them meaning. And in giving them meaning, we're going to be making choices that are going to be informed by our values, including what our impressions are about what would be a desirable outcome of the litigation. With respect to the analysis of factual questions, I think that this kind of analysis is also value laden. Even what are thought of as the most quintessential elements of factual analysis, like witness credibility, the kinds of judgments that people make about whom to believe based on whom they like or what their impressions are about the witness. Another example is the relative significance of different facts. And one I want to really emphasize, because I think it's particularly pervasive, is the use of language. There is no value neutral way to express, to describe any particular set of circumstances. The many words with the same literal meaning have different connotations that carry different valences. There's an idea that philosophers sometimes use the term thick ethical concepts for terms which combine descriptive and evaluative components. So, for example, when we use a word like courageous, someone was courageous, we are on the one hand expressing approval, perhaps admiration. That's the value side. But there's also a descriptive content. It has something to do with acting in the face of fear. And our language, that laws are filled with terms like these. Even when we think that we're describing things, just the facts, just what happened, we use terms that are value loaded. And so because the analysis of both legal and factual questions is pervaded by value judgments, often in ways that overlap, for instance, both are informed by the potential impact on the litigation, I think it's ultimately not possible to keep them compartmentalized.
I have to say, I find that count incredibly persuasive. And it was that type of reasoning that pushed myself in my own work towards the Allen and Pardo model. But you also see shortcomings in the Allen and Pardo conceptualization of the law fact distinction and the myth of the law fact distinction, if you will. So, returning to that second model that already exists that competes with the traditional model, where do you see shortcomings in Allen and Pardo's conceptualization?
Yeah, and just quickly, I should say that I'm using Allen and Pardo as a foil, but their article was extremely helpful, and I recommend it to listeners. It's a really tremendous introduction to the analysis of the topic. But there are at least two aspects of what they say that I agree with. One is that the traditional view is inadequate, and the other is that if you apply their definition of fact, then I think they're right that both traditional legal and traditional factual questions end up counting as facts. But I don't think in the end that that approach captures where the traditional view goes wrong. They define factual questions as questions about propositions that could be true and supported by evidence. It seems to me that that definition is so broad that it includes virtually all kinds of inquiry. And it sidesteps the issue. It doesn't really meet the traditional view on its own terms. The traditional view doesn't purport to be saying anything about truth value or whether propositions can be supported. The distinction concerns what propositions are about, that there are propositions about one kind of thing and propositions about another kind of thing, and that those are two very different kinds of things. And I don't think that by redefining what a fact is so radically that we end up really capturing what is wrong with the traditional approach.
So, given these shortcomings, both in the traditional approach and maybe this new alternative approach, you advance in this paper that we're discussing today a different explanatory model for the law fact distinction. And I really enjoyed reading about your model because I find it really interesting, very persuasive. If you would tell our listeners about your approach.
Yeah, I appreciate that. I should say that I am very much thinking about and working this out. It's always easier to criticize the other models than it is to come up with a full-blown one of your own, but I can at least suggest some directions. So, as it is now, courts use the law fact distinction to decide a number of things in the course of litigation, like whether the jury or the judge will decide an issue. And once we reject the idea that courts can make that kind of decision by tracking a real world distinction between legal and factual questions, the natural question is, well, then what should they be doing? What should be guiding those decisions? And a very common view is to say that at that point, courts should adopt a functional approach. In other words, they should focus on which institutions, judges or juries, appellate courts, trial courts, and so on, are best suited to address certain kinds of questions. As far as that goes, I agree. I think, though, that there is a tendency, once that move is made, once we say, okay, all bets are off, we're not tracking a real world distinction, now we're doing a functional analysis. I think there's sometimes a tendency to treat that as at that point it's a black box, or you don't need to be as rigorous in your analysis. And I do want to mention, Alex, that your piece on this, law, fact, and procedural justice, is a very notable exception to this. It's one of the things I really appreciated about your work on this, because your article takes really seriously, once we move to a functional approach, how do we think about what the values are that we should be pursuing? And in that spirit, I think that we could take far more seriously what does legal judicial analysis look like when we are explicitly appealing to values. I think there are at least a couple reasons why this tends not to be taken as seriously as perhaps it could. One is, I think the extent of the problem is underappreciated. In other words, we rely on the law fact distinction in so many ways. We rely on the idea that we can somehow cordon off factual questions from value considerations. And I think that once we recognize that that's difficult, these kinds of challenges arise all over the place. So it's not just limited to, do we give issues to judges or juries? I think this is a kind of analysis we need to think about more broadly. And secondly, I think there's sometimes a tendency to think of reasoning about values as soft, or that it doesn't lend itself to the same kind of rigor. And I would push back against that. I think it's often the case that the propositions we're actually the most certain of are in the language of value judgment. Let me just mention one example in that regard is that the way we remember events is often coded more in our value judgments about the events than in the details of what actually occurred. So my broad thought is that we could be more systematic about appealing directly to the underlying values. And a couple of ways we might do that just briefly. One is we could not only list the values that we're potentially pursuing, but also translate those considerations into the language of values. What I mean is courts will often say things like, when courts will sometimes explicitly acknowledge that they're engaged in functional analysis, and they'll sometimes list factors like judges have more expertise, or juries reflect the views of the common person, or juries have multiple members. But there's not always a discussion of exactly why that consideration should matter. And I think that if we gave more rigorous systematic thought to why particular considerations, differences between the relevant institutions, matter, and why they might be more salient in some contexts of litigation than others, we might be able to make some progress.
And Steve, do you have any preliminary thoughts on how that analysis might go? So let's take a concrete example. Let's take the issue of negligence, kind of a classic example of an issue that's in that border region between law and fact. How do you think your approach or a follow-on approach might label negligence as a question of law or a question of fact?
Right. So in the case of negligence, the prevalent view that's been the prevalent view for a long time is that that's a question of fact, and that's usually ascribed to the fact that it's a judgment of reasonableness and we want it to reflect community values. But then there are other issues, for instance, issues regarding constitutional rights. And we might think, well, why shouldn't questions about freedom of speech reflect community values? Or why shouldn't questions about the voluntariness of confessions reflect community values? And I think one way of getting a handle on that would be to say that in some contexts, there are values that we would want to place more of an emphasis on. So when it comes to constitutional rights, we might think that there's a high premium on uniformity, predictability, the ability of the citizen to be clear about where the lines are. And so that would make it more desirable for decisions to be made by courts. Whereas decisions about negligence, reasonableness, those kinds of questions are the sorts of questions that arise in daily life that are so varied, so numerous, and perhaps more amenable to our common intuitions, our sense of interacting with other people on an everyday basis, that we might think that in that context, the fact that there are multiple people who are familiar with that particular community, the ability for decisions to possibly vary in different jurisdictions might be something that we would view as more desirable.
Steve, this has been so great. I've really enjoyed this conversation. I think it's such a fascinating topic. And I have just one last question, our classic last question here on Excited Utterance. What's next for the literature? There's been so much said about the law fact distinction. Where do you think the literature is heading moving forward?
Yeah, a couple things I've been thinking about. One is I mentioned that I think the problem goes deeper than is commonly recognized. So there are so many different aspects of our legal system where we tend to emphasize the distinction between law and fact. And so I'd be interested in looking in identifying other areas where that distinction is relevant, and also looking at areas in legal scholarship more broadly where thinking about the breakdown of the distinction between legal and factual questions might have implications. An obvious example would be in legal theory, the classic longstanding debate about legal positivism versus natural law theories or anti-positivist theories. If it is the case that factual questions cannot be cordoned off, then I think that raises really interesting questions about legal theories that purport to base law entirely in social facts, for example. If we can't identify, if we can't describe, if we can't characterize social facts in a way that's value neutral, what does that imply about the theory? And I'll just mention one other one would be debates about interpretation and originalism. Since originalism often emphasizes the advantage that it does not require judicial decision makers to rely on their own value judgments. If it turns out that even the description of historical facts is value laden in a way that's unavoidable, how do we think about that in terms of its implications for interpretation?
Steve, this has been such a great conversation. Thanks so much for coming on Excited Utterance.
Thanks so much for inviting me, Alex. I really enjoyed it.
I really enjoyed my conversation with Stephen today because he opens up an entirely new avenue for scholarship regarding the law-fact distinction. Now, as you heard me discuss with Stephen today, up until this point, up until the publication of his article, there's really been two tracks or two lanes of scholarship when it comes to the law-fact distinction. Now, the most prominent lane, if you will, when it comes to the law-fact distinction, has to be that traditional lane. The view that there's some ontological, analytical, theoretical difference between questions of law and questions of fact, and therefore the classification or categorization of issues should be wholly dependent on just discerning the issue's true intrinsic nature. And here, even though we label this the traditional account, it's by no means a dormant lane of scholarship. There was a fantastic recent paper by Ahmad Atiq talking about the law-fact distinction and distinguishing it on these formalistic grounds. The second major and perhaps more quickly growing lane, if you will, although I'm biased here for reasons I'll discuss, is the lane opened up by Ron Allen and Mike Pardo in their Alabama Law Review piece, The Myth of the Law-Fact Distinction, that you heard Stephen and I discuss. And Ron and Mike take the view that, hey, we shouldn't be so focused on the ontological distinctions, the analytical distinctions between questions of law and questions of fact, to the extent that one even exists. And you heard Stephen say today that that's doubtful for Mike and Ron. Instead, we're just looking at factual questions of a different nature. But even if one exists, we're better served by classifying issues functionally, delegating decision-making authority based on the relative competencies of the jury or the judiciary, rather than just delegating issues based on this elusive, ontological, analytical, formal distinction between questions of law and questions of fact. And it's in this lane that my own Emory Law Journal paper, Law, Fact, and Procedural Justice, comes into play, because I give a potential framework or metric system for making that classification, for discerning, is this an issue that's best served by the judiciary resolving it or the jury resolving it? But within this traditional bifurcated literature, if you will, here comes Stephen's paper, which opens up an entirely new lane, a new vision for the law-fact distinction, insisting that the distinction between questions of law and questions of fact is premised in value-laden decisions rather than any focus on the intrinsic qualities of the issue or the functional consequences of classification. I'm super excited about this intervention, and I imagine, just like Mike's and Ron's intervention not all that long ago, Stephen's piece is going to open up an entirely new lane of scholarship when it comes to the law-fact distinction. Support for Excited Utterance is generously provided by Vanderbilt Law School's Branstetter Litigation and Dispute Resolution Program, as well as the Texas A&M University School of Law. The producer is Ed Chang, and the production editor is Anirudh Barella. Additional assistance was provided by Lexi Creasy, and background music is provided by Kirsten Castle-Greer, Felix Wong, and Alex Crew. I'm your host, Alex Nunn, and I hope you'll join us again next time when we take on another work in the world of evidence and proof.